Did the Department of Justice kill a major civil rights tool? Well, that's a question being asked because on December 9th, 2025, the DOJ finalized a new Title VI rule that eliminates disparate impact from its regulations. That phrase matters for how the U.S. proves and goes after racial discrimination. But here's the change in plain English. For years, if you took federal money, the government could come after you in two ways. If you intended to discriminate, and if your neutral policy had a disparate impact, meaning it hit certain racial groups much harder than others, even if nobody said the word race out loud. That second option, the disparate impact standard under Title VI, the DOJ just deleted it. Let me give you an example of what this means. Previously, a city fixes sidewalks only when people use an online app to report problems. Wealthier, mostly white neighborhoods use the app more, so they get repairs. Poorer, mostly Black or Latino neighborhoods don't and keep broken sidewalks and potholes in roads. Under the old Title VI disparate impact rules, that pattern alone could trigger a civil rights investigation. The impact of this policy is discriminatory. Under the new DOJ rule, that's not enough. Now you have to prove intent, that someone meant for this racial gap to happen to people in these neighborhoods. This shift affects schools, policing, housing, healthcare, environmental justice, and federal contractors, anyone tied to federal funds. Supporters say it restores meritocracy and stops backdoor quotas. Critics say it guts systemic discrimination enforcement because most bias shows up in data, not in a smoking gun email. So here's the real question. Should U.S. civil rights law care only about what people say they mean, or also about what their policies actually do in the real world? Make sure to comment below, give your thoughts. Got any questions? Put them down below. We try to answer and respond to everybody who comments. Thanks for watching.